the presentation that I'm going to give you today is a presentation that I prepared at the request of Utah legislators. I have done some work on sovereignty, on the state sovereignty, and the role of the state in the function of the Constitution. And a Utah state legislator by the name of Curtis Oda called me and said, KrisAnne, I'm going to pull together a good number of our representatives here in Utah, and I want you to come teach them. Don't you know, I was like, yes, that's awesome. Wouldn't you like your legislators in the state of California to learn about the sovereignty of the states? Right, that there is such a thing. Well, that's what we're going to do. And the reason that this lesson has become so popular and so important is because we, the people, do not understand what sovereignty is. We don't understand what our role is in maintaining the control of the government, the federal government, and how much power we actually have. So in this, I want to mention to you that although this says the constitutional role and duty of the state legislator, I want to mention to you this is also the constitutional role and duty of your county commissioner, of your city councilman, of your sheriff. And it's an understanding that you must have as citizens so that you can properly vet the candidates for those slots and make sure that you have constitutionally minded people. May I mention to you very quickly that if the world was perfect according to KrisAnne Hall, you're supposed to laugh there. That's funny. Just kidding. I should have, Barack Obama has those people that say applause. Applause. And pay no attention to my teleprompter. Just kidding. Okay, so if the world was perfect according to KrisAnne Hall, we would completely ignore federal elections for 6 years. Because nothing's going to change in Washington, D.C. in 6 years. So what I would have you do is spend every minute that you would spend campaigning for a federal election and every dollar that you would spend campaigning on a federal election, but dump that into your school board, your city council, your county commission, your sheriff. Because if you did that for 6 years, you would have a constitutionally minded school board. Can you imagine a constitutionally minded school board? I mean, you wouldn't care you would be laughing at the other counties who are succumbing to Common Core because it wouldn't be allowed in your county. You would have a constitutionally minded city council, and you wouldn't care what Agenda 21 did somewhere else either. You would have a constitutionally minded sheriff. Well, if you have a truly constitutionally minded sheriff, you don't care what the federal government is doing because your constitutionally minded sheriff will tell the EPA, you have no jurisdiction in my county and you cannot work here. The FBI, you have no jurisdiction in my county, you cannot work here. The Department of Education, the Department of Interior, the Bureau of Land Management, every one of these unconstitutionally established agencies in the federal government will have absolutely no jurisdiction in your county if you have a truly constitutionally minded sheriff. Now, once you have a constitutionally minded school board, a constitutionally minded city and county, and sheriff, you will be creating a crucible of experienced, constitutionally minded statesmen that you will now be able to send to your capital. And if you can manage, secession might be a little bit easier than taking over your capital, but I'm just saying. If you can manage to have a constitutionally minded capital in the state of California, you will not care at all what the federal government is doing, because you will have no federal government in your land, you will have no federal government in your business, in your lives, in your homes, in your property, and you will have no federal government in your taxes. if you have a constitutionally minded state. But in order to get that, we, the people, remember it was we, the people, in order to form a more perfect union, must understand what a state is, where it derives its power, how we got the federal government, where it derives its power, and where is the ultimate control for everything. One of the problems that we have is that we don't know where we came from. So we have no idea who we are. And by not knowing who we are, we have no idea what our power is. We have no idea how what our obligation is to the Constitution. We've been brainwashed out of all of our responsibility. We somehow believe that voting once every 4 years is the pinnacle of being a good citizen. And we have lived that way for so long, and this may sound a little controversial, we have lived that way for so long that voting actually makes no difference whatsoever anymore. Not on the federal level anyway, which is why I say you could ignore them. If you ignored the federal government for 6 years, not only would you get a constitutionally minded local and state government, but you might actually bring down your federal representatives a couple notches to where they understand that they are employees and not princes. Let them fend for themselves, stop worshiping them, and maybe they'll get back in their right position. And so we're going to hear first. Now, can everybody see this, or do we need to dim these lights a little bit? I will read it to you. You don't have to worry about that. I just want to make sure you can see it. All right. So we're going to hear first from the legislators of the state of Virginia from 1799. Now, this is the best, darkness. This was the best definition of a legislator's role that I have ever found. It says, unwilling to shrink from our representatives' responsibilities. Don't you wish we had some state representatives who were unwilling to shrink from their responsibilities? But maybe they don't, because they have absolutely no idea what their responsibilities are. They think their responsibilities are to gather as much federal funding as they can so they can pass that on to you. But that is exactly the opposite of their responsibility. Watch here. Unwilling to shrink from our representative responsibilities. It would be deceitful in those entrusted with the guardianship of the state sovereignty. They are talking about themselves. They're saying we have been entrusted with the guardianship of the state sovereignty. And we, the state legislators, have been entrusted with the guardianship of the state sovereignty. And it would be deceitful for us who we are acting under the solemn obligation in the following oath. I do swear that I will support the Constitution of the United States. 2 roles your state legislator has. 2 fundamental, primary roles. Everything else comes secondary. Number 1, to guard the state sovereignty. Number 2, to support and defend the Constitution of the United States. Now let me mention to you that they look to be 1 and 2, but when we understand the purpose of the state and the construction of the Constitution, we understand that they're exactly the same thing. Because when the states are no longer sovereign, the Constitution is no longer preserved. So they said, because we are the guardians of the state sovereignty, because we are acting under the oath that we must support and defend the Constitution, we must warn you of federal encroachments. Now, when the world is working in its right order, what comes first, the encroachment or the warning? The warning, right? We got it backwards. If we ever have it. We have state governments competing and fighting for federal encroachments. That's how you got Common Core in your state, by the way, because the very act that created the Department of Education tells the Department of Education you cannot mandate curriculum on the states. So Common Core is not being mandated upon you by the federal government. What happened was the federal government said, we have this Common Core curriculum and will allow you to compete for the funding. And they got around the mandate by making us beg them for the funding, and they said, okay, you win, you get the funding, but you have to take the Common Core too. Now, if your state legislators were doing their job, they would have warned you that this is an encroachment and the destruction of the sovereignty of the state, the ultimate destruction of the Constitution. But they says, it's deceitful of your state legislators not to warn you of encroachments, which, though clothed with the pretext of necessity or disguised by the arguments of expediency, clothed with the pretext of necessity. We must have health care or we're all going to die. I got bad news from you. We're all going to die. National health care just allows the federal government to decide who dies, when and where and how they die. But they also said, watched out, they may be clothed in are disguised by the argument of expediency. Remember, you got to pass the bill so you can read the bill. Now, I'll remind you, this was written in 1799, not 1999. And then they concluded by saying, if we allow these encroachments, even though we may be able to tell the people they're necessary and needed right now, we will establish precedents which will ultimately devote a generous and unsuspicious people to all the consequences of usurped power. And what are the consequences of usurped power? That once the federal government breaks out of its box, there is no more limitation. And everything is under the rule and reign of the federal government. And that's exactly what the Affordable Care Act does. It allows the federal government to rule and reign over every aspect of your life, and the Supreme Court will uphold it. Because many years ago, the Supreme Court established a standard for our government called a compelling governmental interest. And the Supreme Court says that as long as the federal government can establish that it has a compelling governmental interest in something, they can trump your rights. Which means, if they have a compelling governmental interest in national security, your Fourth Amendment means nothing. It's exactly why the NSA can read your emails, listen to your phone conversations, record your internet data, because the Supreme Court knows they have a compelling governmental interest in your national security. So I'm going to walk through that a little bit more for you a little bit later, but I want you to show you just exactly what we need to do. Because remember, that was written in 1799, and they're describing exactly what we're going through today. And what we need to understand is what Patrick Henry said. I have but one lamp by which my feet are guided, and that's the lamp of experience. I know no way to judge the future but by the past. Those who do not know their history are doomed to repeat its mistakes. Because history always repeats. Ever heard of a guy named Solomon? He said there's nothing new under the sun. Human nature never changes. Alexander Hamilton said experience is the oracle of truth, and where its responses are unequivocal, they ought to be held to be sacred and conclusive. Einstein said it a little bit differently. If you do the same thing over and over again and expect different results, that's the very definition of insanity. But yet, because we have had our history stolen from us, we have been doomed to repeat the mistakes that have been made over centuries. And I know history, so I know who's learning, and it's not us. It's those who would steal your liberty and be tyrannical over your rights that know exactly how to do it and make it better all the time. So what we're going to do is we're going to understand a little bit of history as it applies to the sovereignty of our states. And the first question that I want to ask you is, who came first? The states or the federal government? Well, that is a no-brainer, right? It absolutely is. But I think even though that is a no-brainer, because we do not stop to connect the dots, we are led down the wrong path, and we are misled and miseducated about things into improper roles of government and even into submission. So let's talk about this for just a second. States, we did not, and this is something that we have been taught wrong for a long time, we did not become independent from Great Britain on July 4th, 1776, with the publishing of the Declaration of Independence. We became independent from Great Britain on July 2nd, 1776, with the ratification of the Lee Resolution. The Lee Resolution, named after a framer named Richard Henry Lee, was presented to the Continental Congress on June 7th, 1776. It was an adaptation of a resolution that had been created by the state of Virginia. And in the Lee Resolution, Richard Henry Lee gave the Continental Congress a 3-step process to declaring independence. Step number 1, we are 13 independent sovereign states because we say so, and we don't need anybody's permission to be so. Step number 2, we must gather foreign alliance. Because another thing that we're mistaught, taught improperly, or not taught at all, by the time we declare independence in 1776, we are already fighting with our own government. Now, I'm not talking about Boston Tea Party type protests. I'm talking battlefields and bullets for nearly 2 years before the Declaration of Independence is signed. It's why Patrick Henry said in the St. John's Church, "Why sit we here idle? Our brothers are already fighting in the field." He was not speaking, what's the word I'm looking for? Rhetorically, right. He was speaking realistically. Battlefields and bullets. The first shots fired on March 5th, 1770. And so we were already occupied by our own government's military by the time we declared independence. There had been 2 quartering acts issued. There were soldiers in our homes and in our businesses. And guess what? We did not have the manpower or the resources to overthrow our occupancy. Because you see, Great Britain's still the greatest military in the world at that time. The greatest navy. The sun never set on the British Empire. We had to get, in step number 2, foreign alliance. We had to get foreign aid. That foreign aid would come in the form of France, Spain, and Holland. Now, we can't believe that France, Spain, and Holland would volunteer to help us with our independence from Great Britain just because they were a bunch of nice guys, right? They're looking for something out of this. Everybody wants new territory in the new world. And so if they come over to help us, and they have a liking to one of our colonies, if we didn't have step number 3, we must immediately form a confederation. By the time the battle was over, we'd be parceled out as little pieces of France, little pieces of Spain, little pieces of Holland, and little pieces of Great Britain. Imagine, France is in New York. It's a small state, and they say to the newly formed states as they gain their independence, "You guys owe us a really huge debt." You can't deny that. But we'll make a deal with you. We'll take this New York as payment for our debt, and we're clean. You don't owe us anything. Without a confederation, that would happen. But with a confederation, we would be able to look at France and say, if you try, it's not just New York you have to deal with, it's all 13 of us. And France would not be prepared to do something like that. Thomas Paine said, it's not in numbers that we gather our strength, but in unity. So the Lee Resolution was presented to the Continental Congress June 7, 1776. It was debated, voted, and ratified on July 2nd, 1776. And then on July 4th, 1776, we signed the Declaration of Independence. We're going to be reading part of that in a little bit, and you'll see what the Declaration of Independence tells exactly what its job was to publish and declare, not to create. So that means the states existed not only prior to the federal government, but prior to the Declaration of Independence, right? Because the states were formed on July 2nd, 1776. We also know that the states existed prior to the Articles of Confederation because they existed here, or prior to the Declaration of Independence. And then when we dissolved the Articles of Confederation and created the Constitution, the more perfect union, the states still existed. Now this is the point right here where we get our federal government. 11 years have passed between here and here. 11 years of states before you have Congress, the executive branch, and the judicial branch. That's very, very important to recognize so that we can understand where to go from here. So, understanding that the states existed prior to every other government in our known world today, or our known country today, we now need to go back and understand what is a state. Now, when I travel and teach, I sometimes get to teach young people. And the other day, I was teaching them, and it occurred to me I should play a game with them. How many of you have heard of a game called free association? The psychologists play that. They say a word, and then you say the first thing that comes to mind: orange, banana, green, blue, that kind of thing. And so what I did with these students, these were middle school students, I said, okay, I'm going to play a game with you. I'm going to say a word, and I want you to say the first thing that comes to mind. And I said, state. They said, Colorado, because that's where we were. I said, okay, I'm going to tell you, in other words, I want you to tell me something different. State. Florida, state. Nebraska, state. Wyoming. Good job, guys. That's exactly what I thought you would say. So we need to learn what a state is, because that's not what our framers thought when they wrote this word states. We, therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do and in the name and by the authority of the good people of these colonies, now catch this, we are colonies, solemnly publish and declare. This is the purpose of the Declaration of Independence, to publish and declare. Now watch this transition. That these united colonies are, and of right ought to be, now not colonies, but free and independent states. Now it's a transformation because a colony is a subset of a kingdom. Colonies have no sovereignty, which means they cannot act of their own accord. They must act according to the will of the kingdom. They have no ability to function outside the realm of the kingdom. Colonies are a subset of a kingdom. We are leaving the state of colonies, and we are now becoming free and independent states. But again, what is a state? We read on in the Declaration of Independence and find out that as free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain. You see, if you played free association with our framers in that word state, they'd have said state, Great Britain. State, France. State, Spain. State, Holland. Because for them, a state was not the subset of a union, as we've been brainwashed it to believe, but an independent, free and sovereign government. There is no difference between the state of California and the state of Great Britain. Maybe you still don't believe me yet. Let's keep going. So, are totally dissolved from the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, remember, like the state of Great Britain, they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states like Great Britain, France, and Spain may do. Each and every state was created in the sovereign image of Great Britain, France, and Spain, and carried every single power that France and Spain and Great Britain carried. Independent, sovereign governments. Every single state. And nothing has changed. Just because we became a union does not change the sovereignty of the states. Don't we have a European Union? Isn't there a European Union? All right, fly over to Germany. Tell the German chancellor and the German people they are no longer a sovereign country because they are part of the European Union. How do you think that's going to go over for you? We expect them to laugh in our faces, right? So why don't we have the same response when the federal government tells our states that we have no sovereignty? Because we are exactly the same. We are free and independent, sovereign governments who were no longer subsets to a kingdom. Tell me something. Why in heaven's name would we go to a bloody war with our own government to stop being subsets to a kingdom only to become subsets to a federal union? That doesn't even make sense because it didn't happen that way. Let me give you an illustration very quickly. I want 4 ladies to stand up right now where you are. All right, got 4. All right. Now, you will recognize these 4 ladies are independent, are they not? You will also recognize that these 4 ladies are sovereign, right? Sovereign means they have control over their own selves. Nobody rules over them. Nobody makes their arms move and their lungs breathe. They are sovereign. So now what I want these ladies to do is come forward right here in a circle and join hands. We got one more coming in. That's all right. More the merrier. What have these ladies just done? Formed a union. Did they just become one big lady? Thank you, ladies. You can sit down. That's exactly what we did when we formed the United States. The states came together and held hands, as the Constitution says, for their mutual benefit and their mutual protection. They did not become one big amalgamous government. They remained independent and sovereign and only formed a union so that they could work together more efficiently. And in that sovereignty, they all, and this is very important, so if you're taking notes or making mental notes, remember that on July 2nd, 1776, because this language right here is copied almost completely verbatim from the Lee Resolution, these states now carry the power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which Great Britain, France, and Spain might do. How many people in the state of California know that to be so? The sovereignty of the states is the key to maintaining the integrity of the Constitution and preserving liberty. Why? because the states are the creators of the central government. That's a new idea, isn't it? Well, I'm going to prove it to you, but let's think about that. What government existed on September 16th, 1787? The states. That's it. The federal government did not exist until the Constitution was ratified on September 17th, 1787. So they had to come from somewhere, and so they had to come from a sovereign government, and the only sovereign governments that existed prior to the federal government's existence were the states. Now, how did the states create the central government? Well, they enumerated its powers and created a limited government through and reserved all the rest of the powers to themselves through the Constitution. Watch this. James Madison said, "I, sir, have always conceived, and I believe those who proposed the Constitution conceived, and it is still more fully known and more material to observe that those who ratified the Constitution conceived that this is not an indefinite government, but a limited government tied down to specific powers." Now, this statement is very interesting, by the way. As you'll notice, the date is 1792. James Madison is making an argument before the legislation, the House of Representatives, and telling them, look, if you allow Congress to interpret the General Welfare Clause to mean that they can do whatever they generally please, then the next thing you know, Congress will be spending money on education. Congress will be spending money on religion. Congress will be spending money on our roads. And everything, he says, to the daily activity of our states, down to the minute powers of police, will be funded by Congress, because they will have the argument that every one of those things involves money. And since the General Welfare Clause means that Congress can do whatever they generally please based on their expenditures of money, he says if you allow Congress to believe that and act like that, you will transmute the very foundation of who we are from a republic to a monarchy. By the way, you know what he was arguing against? The federal government subsidizing cod fishermen. Do you know what's wrong even in our conservative circles today? We want a limited federal government, but we don't. I want a limited federal government as long as I can have my Medicaid motor scooter. I want a limited federal government as long as my kids and my grandkids can get federally subsidized student loans. I want a limited federal government as long as we can have those farm subsidies. Now here's one that'll probably make enemies and make somebody have to escort me out the room. But how many of you realize the truth is not fair and balanced? But it needs to be told nonetheless, right? Are you prepared? I want a limited federal government as long as the federal government will define marriage for me. Because the definition of marriage is not a power delegated to the federal government. And asking them to do that and giving them permission to do that gives them permission to escape their box and do everything else they want to do as well. Now look at these powers, because I asked you to make a mental note about our Declaration of Independence. Madison says in Federalist Papers 45, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to, what's that magic word there? Remain in the states. Remain. What does that mean if something remains? It stays where it started, right? So some powers are remaining and some powers are being delegated. That's very important. We're going to tie this all together. So the powers being delegated are few and defined. Those which are to remain in the states are numerous and indefinite. The former, meaning the powers delegated by the proposed Constitution to the federal government, will be exercised principally on external objects. Now that's how they described foreign affairs. War, peace, negotiation, and foreign commerce. That is all your federal government has ever been delegated power to do. Foreign affairs, as they apply to war, peace, negotiation, and foreign commerce. Everything else was to what? Remain in the states. Now, do you remember this? War, peace, negotiation, and foreign commerce. Does that sound familiar? Because that's the power that we delegated to the states when we created them, right? All power to make war, levy peace, contract alliances, and do all other things which states like Great Britain and France and Spain can do. Isn't that what the Declaration of Independence said? Well, now we are delegating power, this power, to the federal government. So if power is delegated, doesn't that mean there has to be a delegator and a delegate, right? So the delegate of the power is the federal government. Who is the delegator? The states, because they started with the power. Now watch, Madison finishes and says, the powers reserved, they not only remain, okay, but they're also reserved, which means nobody else can use them. They are reserved to the several states, will extend to all, and I know we like to redefine the meaning of the word is, but in today, all still means all, right? All the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order and improvement and prosperity of the state. I don't know, can it get any clearer than that? Your federal government is only delegated power to war, peace, negotiation, foreign commerce, foreign affairs. Everything else stays in the states. Now listen, war, peace, negotiation, and foreign commerce. Everything else. Are there powers floating around in the ether somewhere waiting for someone to use? No, because it's either this or everything else. So if the federal government is doing something besides war, peace, negotiation, and foreign commerce, where do they have to be taking that power from? The states. So if the federal government uses powers outside the Constitution, it must steal that power from the states. Well, Calhoun tells us in 1831, when they're going through the same problems that we're having today, if you're interested in seeing how our future may play out, you need to investigate a time in our history called the Great Debate of 1830. And when you research the Great Debate of 1830, you will find out why the federal government attacked us in the Civil War. Because it didn't really have anything to do with slavery, it had to do with what was happening through the Great Debate of 1830. And I know that's really controversial, but test me out. Calhoun says, at a time when the federal government is trying to steal power from the states, the doctrine which denies the states the right of protecting their reserved powers, catch that now, Madison already told us that they were reserved in Federalist 45, reserved powers, which would invest in the general government. Now this parenthetical is very, very important. He says, it matters not through which department. How many branches of federal government do we have? I mean, on paper. 3. We have the legislative branch, the executive branch, and the judicial branch. So before we go any further, can we at least have an agreement in this room that the judicial branch is part of the federal government? Do we all agree? Okay, so Calhoun is saying it doesn't matter which department is usurping the power. It is the right of the states to protect that power. Now, it is the right of the states to determine if we allow the federal government to determine exclusively and finally the powers delegated to it. So the federal government is in charge then of the limitation of their own powers. He says It is incompatible with the sovereignty of the states and of the Constitution. Why? Because the states created the federal government, delegated power to the federal government in a limited and defined manner. And if the federal government can choose what its power is and what its limitations are, then the states are not sovereign, because then the federal government rules over the states instead of the other way around. And if the federal government rules over the states instead of the states ruling over the federal government, that is incompatible to the Constitution, because the Constitution created a limited and defined federal government. And if the federal government is not limited and defined by the Constitution, then what is the purpose of the Constitution? Jefferson said that whenever the general government assumes undelegated powers, its acts are unauthoritative, void, and of no force. Why? Didn't we establish that if the federal government is doing something besides war, peace, negotiation, and foreign commerce, it has to steal that power from the states? Right? Is stolen power a valid power? If I steal your car, do I have the legal authority to sell it? Do I have the legal authority to allow someone else to use your car? Absolutely not, because it is a stolen authority. It is an apparent authority, but not a real authority. But if I let you drive around in my stolen car all day long and I don't ever complain, at what point does it transfer from being apparent to real? Now let me ask you a question. If I steal your car, do you have to sue me to get your car back? No, you do not. I was a prosecutor and involved in criminal law for nearly a decade. I can tell you unequivocally, you, as the owner of the vehicle, do not have to sue the thief. All you have to do is show the titled deed, your proof of ownership of that vehicle, and that car is returned to you. Now, if for some reason I had actually sold your car, the poor sap that bought the stolen car is now the one that has to sue to get his money back. He has to hand over your car to you and lose everything that he paid because you have the title deed. Now, think about that. If the federal government is using power beyond what's delegated, it has to steal from the states, right? Do the states have to sue the federal government to get their power back? Absolutely not. All the states have to do is show their title deed. What is the title deed to their power? The Constitution. Do you know how ridiculous it is and how dangerous it is for the states to sue the federal government? First problem. Where are the states suing the federal government? In federal court. Who appoints the judges in the federal courts? How do we think that we are going to have any kind of real justified outcome in a federal court when the state is suing the federal government in a federal court stacked with their judges? Now, the second problem with that is the fact that we are completely infested in this country with federal supremacists. People who believe that the Supreme Court and the courts in our country are the ultimate arbiters of everything. And so when you sue, the states sue the federal government in a federal court, they have to know that 9 times out of 10 they're going to lose. And when they lose, what they have actually done is 2 things. They have empowered the federal government to a greater degree to steal their power, and eliminated the efficacy of the real solutions. Because the federal supremacists will say, you had your shot. You gave it to the courts and they just decided you were wrong. As my sergeant would say, now you just have to suck it up and drive on. Well, that's not our solution. What is our solution? Madison says, in the case of deliberate and palpable and dangerous exercise of other powers not granted, the states have the right and are duty bound to interpose What does interpose mean? Interpose means the states have an absolute obligation to stand between you and the federal government's theft of your rights. Interpose means they're actually going to eclipse you so that they hide you from federal theft. Because when the federal government is stealing power from the states, what they're ultimately doing is stealing your liberty. Because remember, the states have been entrusted to be the guardians of the sovereignty of the state, and the sovereignty of the state is entrusted to keep within the respective limits the authority, rights, and liberties. So when your states fail to act, the federal government has direct access to you, right? And that's how you have the EPA stealing your land and your property, and the Bureau of Land Management and the Department of Interior and the FDA and all these other agencies. Well, Jefferson gets a little bit clearer. The several states who formed the Constitution, as if you have to believe me, right? Remember I told you it was the states that formed the Constitution. The several states who formed the Constitution being what? Sovereign and independent. Here we are in 1799, Jefferson saying we're sovereign and independent still. Here's another key that we have to recognize. The Constitution is a contract between the states. If you are not sovereign, you cannot create and engage legally in a contract. That's why your 15-year-old cannot sign a contract legally, because your 15-year-old is not sovereign. Your 15-year-old is still under the rule of the parents and is not free to do whatever they want. A 15-year-old cannot legally engage in a contract without his parents because he is not sovereign. So, if the states are not sovereign, then they can't have legally created the Constitution. And if they can't have legally created the Constitution, then the Constitution does not legally exist, the federal government does not legally exist. And we are independent and sovereign. The several states who formed the Constitution, being sovereign and independent, have the unquestionable right to judge of its infractions on the Constitution. And that at nullification by those sovereignties, who are the sovereignties? Of all unauthorized acts done under the color of that instrument is the rightful remedy. Why is the nullification of any act done by the federal government outside the Constitution the duty and rightful remedy of the states? Because it's their power. And the federal government is stealing it. If I steal your car, can your neighbor get your car back? No. Whose duty is it to get your car back? Right. If the federal government is stealing power from the state, whose duty is it to get it back? The states. Now, we are 30 minutes into this presentation, and I am just now mentioning this word nullification. I have done that on purpose. Because you see, if you're going to discuss nullification with anybody else, you have to get them to understand sovereignty first. Because nullification is a nasty, dirty word in our society today. Nobody warned me. I'm warning you so you don't have to suffer the way I did. Okay, nobody warned me. Now see, I don't read other people's books. I was a linguist in the Army, and I was taught as a linguist the only way you can understand a document is by interpreting it through original writings and original text. So I don't read other people's books. The history that I write about in my books that are in the lobby, the history that I teach you, is all gathered from original source documents. So I literally stumbled upon this understanding of nullification from reading the doctrines. And now, in the original documents. Now, I did not invent this principle. Jefferson and Madison recognized it, but there are lots of people who have written about it. I just didn't read their stuff, so I didn't know. And when I stumbled across this principle of nullification, I got really excited. I thought, oh my goodness, why are we spinning our wheels and running around and scratching our heads and wondering what we're going to do about this federal government problem? The answer is right here, and it's so simple. So I marched myself up to my state capitol in Florida and gave a presentation on nullification to the Senate Judicial Committee when they were talking about the establishment of the health exchanges for the Affordable Care Act, right? Because the states, in order to keep the Affordable Care Act out of your state, they simply have to tell the federal government, health care's ours, not yours. So it's just void here. It has no authority. That's all it is. That's all it takes. And so I gave that presentation. It did not go over well. After the presentation, by the way, you can see the video of the presentation on my YouTube channel. It's very interesting, actually. It was kind of ruckus. Anyway, after the presentation, our Senate president came into the committee hearing. He was not part of the committee, so he didn't come in. And one of my friends, introduced me to our Senate president. His name is Don Gates. He's a Republican. And so I know now that my friend was laughing the whole time he was introducing me to him, because he knew me and he knew Don Gates, but he knew that I didn't know Don Gates and didn't know what to expect. So I introduced myself to Don Gates and I say, hey, Mr. Gates, it's nice to meet you. My name is KrisAnne Hall. Oh, hi, Miss Hall. It's fabulous to meet you. I said, I think so too, Mr. Gates, and I hope that we can see more of each other. He said, oh, Miss Hall, that'd be fantastic. I said, oh, really, Mr. Gates? Because you're the Senate president, and I'd really like to address the Senate on the principles of nullification. Nobody warned me, I told you. And my friend knew, so he's back there going, getting a laugh at my expense. People sick me like a bulldog. I don't understand that. I'm not, am I scary? Anyway, Don Gates hears me say that word nullification, literally steps back, throws his hand on his hip and cocks his hip and says, nullification, huh? I guess the Supreme Court didn't get your memo. And my first thought is, who's this guy? He's an employee talking to me like this? And I said, my memo? I guess they didn't get Madison, Hamilton, or Jefferson's memo either then, did they? He says, oh, it's not done yet. He says, Madison, huh? Talked to Madison lately? I said, well, as a matter of fact, I have. It's called the Federalist Papers, and maybe you ought to read them every now and again. At which point, he realizes that I'm not his average person that he's used to dealing with, and I'm not going to back down when he puffs up like a blowfish. So he turns his back on me and starts mumbling things about dead people in irrelevant documents. And so, I don't know about you, but when I get in those situations, I get like tunnel vision. I have no concept of my surroundings. It's just me and him in the room. He gets about as far away from me as the guy here in the striped shirt. Now, he's walking out the door, and I'm still standing there stunned that he would talk to me like that. And I said, hey, Mr. Gates, I thought you called yourself a constitutional conservative Republican. Now his back's to me. He spins on his heels and points at me and says, I took an oath to support and defend the Constitution. I said, maybe you ought to learn something about that document, don't you think? At which point, Mr. Gates realizes something that I have no concept of. We had just come out of a Senate committee hearing, and there are a whole crowd of people behind me. Some of them press. His whole demeanor changes. Oh, Miss Hall, I'd be happy to see anything you'd have to send to me. Just send me an email. And so I did. I wrote up a primer based on the framer's writings on nullification, and I emailed it to him. He actually responded to me. He sent me an email and told me that he thought that I should be shot or hanged for even suggesting that the states would be supreme over the federal government. The Huffington Post asked him about it. He said, well, of course, I didn't mean we should go around shooting and hanging people. I just wanted Miss Hall to realize that we could disagree and still remain civil. Like the fine man said, you can't make this stuff up. So I'm just warning you. You need to talk about sovereignty before you talk about nullification. Because you are going to meet people that will say no to nullification. They're going to tell you it's not in the Constitution. You're going to tell you the Supreme Court said no. They're going to tell you the Supremacy Clause prohibits it. And they're also going to tell you possibly that the Civil War settled that issue, which is just as hilarious as the other three. But those who lived the ratification of our Constitution disagree with all the federal supremacists. Now, that claim that it does not exist in the Constitution can be defeated with one argument: the Ninth Amendment. The Ninth Amendment declares the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. By the way, the Ninth Amendment is the most important clause in the entire Constitution and Bill of Rights. It is the Ninth Amendment that makes us a republic and not a kingdom. And it is the Ninth Amendment that declares that all the rights in the universe belong to the people, whether they're written down or not. That was the purpose of the Ninth Amendment, because there was an argument about the Bill of Rights. Some people said if we write down these rights, the federal government will say, that one's not on the list, so it must be ours to regulate. Madison drafted the Ninth Amendment and said we can stop that argument by simply declaring that every right in the universe belongs to the people, whether it's written down or not. Now, what are our rights? Samuel Adams wrote a dissertation in 1772 called The Rights of Man. And in this dissertation, Samuel Adams said, among the natural rights, meaning they're yours by the nature of your creation, among the natural rights of the colonists. Now remember, colonists are subjects to a king, right? Wouldn't you think that people who live in a republic would have more rights than a colonist? Okay, so now we're talking a baseline of colonists. Among the natural rights of the colonists are these: first, life; secondly, liberty; third, property; together, number 4, with the right to protect and defend them in the best means possible. Now, for colonists, quite often, the method by which you protect your life, your liberty, and your property is rebellion. That's the best you got when you got a king. Because you're not going to start a recall petition to get rid of your king. You're not going to find a new king to run against him in the next kingly election. If you want to get rid of your king, chopping off his head is quite possibly your only solution. But we are not colonists. We are free men in republic, which means our right to life, liberty, and property is assured. But that right to protect and defend it in the best means possible just got bigger. And our right to protect our life, our liberty, our property is exactly what we're doing in nullification, right? Didn't Madison say that it was the right and the duty of the states to interpose to protect the liberties of the people? We are protecting our liberty, our life, and our property from the federal government through the power we have delegated to the states. So we don't have to chop off heads. Because without the states, all we have is rebellion. The 10th Amendment delegates powers to the federal government, which is why nullification works. When we delegate power, does that mean the same thing as surrendering power? No. Delegate means a temporary transfer of authority to do a job for me. Now, we've already established, right, that the states delegated power to the federal government because it belonged to them first. So they've clearly delegated power to the federal government. And remember, everything else is reserved to the states, respectively, or to the people. Why to the people? Because we hold all the rights as proven by the 9th Amendment. Power emanates from rights. We delegated power to the states in 76. The states delegated a limited and defined portion of their power to the feds in 1787. Delegated, not surrendered. Let's do an illustration. Let's just pretend that I am the owner of a Chick-fil-A restaurant. Okay? Brand new Chick-fil-A restaurant. No employees, just me. Now, if I'm Superwoman, I can make all the chicken, all the fries, and all the lemonade all by myself, right? Because I'm Superwoman, I can do that. But I'm not. In spite of what you may have heard, I'm not. So I have to hire people to help me. I hire somebody to make the fries. I hire somebody to make the chicken. I hire somebody to make the lemonade. Whose power was that first? Mine. I have now hired and delegated authority to the fry guy and the chicken guy. What happens if the fry guy comes in one day and says, I ain't making no fries? Am I out of luck for fries? Do I have to go, oh, please, come make our fries, because if you don't make our fries, I don't have any fries. Is that how it works? Right, I tell them hit the road and I hire somebody else, or I do it myself, right? So, in another scenario, what happens if the fry guy comes in one day, kicks the chicken guy off the grill, and says, I ain't making chicken, I ain't making fries, I'm making chicken. Does he have the authority to make chicken? No. What is my job now as the original possessor of that power? I'm supposed to pick up the chicken guy off the floor, dust him off, put him back on the grill, and tell the fry guy, make fries or hit the road, right? So here we go. The states have delegated power, limited and defined power, war, peace, negotiation, and foreign commerce power to the federal government. So what happens when the federal government shows up to the states one day and says, sorry, we ain't making no fries. We're not going to protect your borders. Are we doomed because the federal government will not protect our borders? What should we be doing? Protecting our own borders. Why? Because that power belonged to us first, right? So what happens if the federal government comes in and kicks the chicken guy off the grill and says, well, I ain't making fries, I'm making chicken. I'm not going to protect your borders, but I'm going to do health care instead. What should we be doing? Telling the federal government, health care is not your power. We never delegated that to you. Get back to protecting the borders, or we'll do it ourselves. So it is in the Constitution. It is in the Constitution as our natural right under the 9th Amendment, and as our duty under a delegated power of the 10th Amendment. SCOTUS, that stands for Supreme Court of the United States. Somebody's going to tell you, well, the Supreme Court said nullification's no good. Well, James Madison disagrees. And I love this quote by James Madison because it's direct, it's to the point. You can't even accuse me of cherry picking because it says exactly what it says and you cannot dispute it. If the decisions of the judiciary be raised above the authority of the sovereign parties to the Constitution. Who are the sovereign parties to the Constitution? If the decisions of the judiciary be raised above the states, the dangerous powers not delegated may not only be usurped and executed by other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. The states even have authority over the Supreme Court. Look at this, he says, consequently, that the ultimate right of the parties to the Constitution — who are the parties to the Constitution? The ultimate right of the parties to the Constitution to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or legislative, because the states are supreme even to the Supreme Court of the United States when it comes to matters of the Constitution. Now okay, so I just came from Coeur d'Alene, Idaho. Coeur d'Alene, Idaho had a Liberty Summit, and they asked me to come and teach this. Well, their attorney general showed up with his attorney in tow. And we had an interesting discussion. And his discussion was, well, the states don't have any authority to tell the federal government to get off our land. And I said, well, excuse me, but I beg to differ, and so would the framers of our nation. Because the federal government has no authority to tell the states what to do with their land. He says, well, the Supreme Court says. I said, the Supreme Court doesn't have the authority to say. He says, well, in Marbury versus Madison, the Supreme Court said. And I said, you know what you've just done? You have just told me that the Supreme Court has a power because they say they have a power. That's circular logic. How does that come out of the mouths of a trained attorney? Do you know what he said? I have to go to the bathroom. I said, well, you know, I'm about to teach this in about 30 minutes. Maybe you should come and sit and listen to what I have to teach, because it might be something that is controversial to you, and we can have a discussion later. So he was in the assembly room listening to the guy speaking before me. He saw me get up and get on the stage, get ready to speak, and he walked out. It's called cognitive dissonance. I am not allowed to be challenged in what I know to be true because it scares the mess out of me. Well, the judiciary is not supreme to the states, because if the judiciary is supreme to the states, then the judiciary is supreme to the Constitution, and then the Constitution is not the supreme law of the land the federal government is. Which brings us to the next point, and my favorite argument, because they gave me this one too. The Supremacy Clause the Supremacy Clause prohibits nullification because it establishes that the acts of Congress are supreme to the states. No, it doesn't. And to claim that just proves to me that they're illiterate. Because in order to read and understand the Supremacy Clause, you just have to have about a 6th grade reading level. Now listen to what Alexander Hamilton says. Now Alexander Hamilton is arguably one of the biggest government guys that we have in the formation of our union. And so think about this from the big government guy. Now that's nothing compared to what big government is today, but I'm just saying comparatively speaking. Alexander Hamilton says in Federalist Papers 78, no legislative act, therefore contrary to the Constitution, can be valid. Not quite sure how simpler we can make that. But now, in true founder form, Hamilton not only tells us what should be, he tells us what happens if we ignore it. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this, he says, would be to affirm that the deputy is greater than his principal, the servant is above his master. Because did you know that the federal government was supposed to be a deputy to the states? And the federal government was supposed to be a servant to the states? And that the representatives of the people are superior to the people themselves. Now you know why your congressmen treat you like a peon. Because we have allowed them to make acts contrary to the Constitution. We've allowed those acts to be valid for so long. We have declared them superior to the Constitution. And Hamilton says, hey, we the people, in order to form a more perfect union, you are the Constitution. And when the federal government is superior to the Constitution, you have allowed them to declare themselves superior to you. And if we do that, he says then, that men, by acting a virtue of powers, may do not only what their powers do not authorize, but also what they forbid. And now we've come full circle with the Affordable Care Act. Because the Affordable Care Act not only authorizes the government to do something it's not allowed to, it does not have power to do, but it also allows the federal government to do something that it's completely forbidden to do. Healthcare is not a power delegated to the federal government. That's the powers do not authorize part. But there are provisions within the Affordable Care Act that deny you your freedom of religion. And that's the forbid part. Why? Because we have allowed legislative acts contrary to the Constitution to be valid. So let's look at the Supremacy Clause. The Supremacy Clause reads, "The Constitution and the laws of the United States are the supreme law of the land." No, that's not what it says. Look at the punctuation. This Constitution, comma, and the laws of the United States which shall be made in pursuance thereof, semicolon, shall be the supreme law of the land. The Constitution is the supreme law of the land, and laws of the United States made in pursuance to the Constitution are the supreme law of the land. Saying exactly what Hamilton said in Federalist 78. No legislative act, therefore, contrary to the Constitution can be valid. Because if the laws of the United States are not in pursuance to the Constitution, they are not the supreme law of the land. They must be in compliance with the Constitution in order to be supreme. And in order to be in compliance, the legislative acts must be limited to war, peace, negotiation, foreign commerce, foreign affairs. Any legislative act beyond war, peace, negotiation, and foreign affairs, foreign action, is now not in pursuance to the Constitution and cannot be supreme. Think about this from the negative. If the laws of the United States, regardless of the Constitution, are now the supreme law of the land, what is supreme, the laws or the Constitution? No. Listen carefully. If we allow the laws of the United States to be the supreme law of the land, even when they're not in compliance to the Constitution, what is supreme, the Constitution or the laws of the land? The laws. Because the laws don't have to comply with the Constitution, so now they can do anything they want that is not in compliance to the Constitution, to include overriding the Constitution, which means now the laws are over the Constitution. And when the legislative branch is superior to the Constitution itself, then they can write laws and overturn laws and set aside laws, even when those laws are contrary to the Constitution. Which means, what's the purpose of having a Constitution? Well, it is no protection if the federal government can do whatever they want. So, we are now back to the legislators of 1799. Remember those who told us what the duties of our legislators were? And now they're going to tell us the consequences if your states fail to guard their sovereignty. The acquiescence of the states under infractions of the federal compact, that's the Constitution, would either beget a speedy consolidation. You see, we formed a confederation, which left us with 5 independent ladies, not one big lady. But when the states just give in to the federal government, to whatever interpretation of the Constitution they choose, then we are no longer 50 United States. We are now 50 colonies, subsets of a federal government. A consolidation, not a confederation. Why? Because if our states just give in and kowtow to the federal government no matter what they want, they will precipitate themselves into impotency and contempt. Right? If the federal government rules and reigns over the states, and the states have no power, no say-so over their creation, the creation becomes superior to the creator. Mary Shelley had a name for that. You know, we have a Frankenstein federal government. It's a monster. It's an abomination. And when the states just simply allow the federal government to do whatever they want, what is the purpose of a state? Why are we even paying state legislators? Because all they are then are a clearinghouse for the federal government to take your money and hand it back out to you again. Because they're just basically the barons and lords underneath the federal empire. Why are we paying them then? Why don't we dissolve our federal governments and just simply become a kingdom again? And when your state representatives look at you and say, we have to do this because the federal government says so and we have no authority to stand up to the federal government, then you need to look them dead in the eye and say, why do we need you? Because we can just submit like that all by ourselves. We don't have to pay you to pillage and plunder us. We can just send all our money to the feds and they'll do that quite nicely without you. But not only that, this is the worst thing. Not only will our states become impotent, but they said, or prepare the way for revolution. You know why? Because the states are impotent. We are subjects now to a federal government because we have no intermediary. We have no peaceful means to control our Constitution because we are no longer a republic. We are a kingdom where the federal government is the only limitation of its own power. And when you live in a kingdom, your only option to change your government is through revolution and chopping off heads. So when your states fail to engage in their duty to preserve the Constitution and protect your liberty, they transform you into a kingdom and leave you no peaceful means to control the federal government. Because they said, look, a repetition of these infractions until the people are aroused to appear in the majesty of their strength. Remember, Jefferson says that the governments are instituted among men, deriving their just power from the consent of the governed. And whenever any government operates contrary to those means, it is the right of the people to alter or abolish, establishing new governments. When you are a kingdom, your only opportunity to alter and abolish is through rebellion. But as a republic, your opportunities to alter and abolish are unlimited and only limited by the power of the people. But now that we have engaged in a situation where we have no states with no sovereignty, they are pushing us to the point where there are no other options. And that's why your states must act now. And if your states won't, your counties must. And if your counties won't, your municipalities must. Because at some point, the government has to fulfill its function to preserve the blessings of liberty. That's the whole reason we have the Constitution. Read the preamble. It's not to establish a military. It's not establish the Federal Reserve. It's to preserve the blessings of liberty. All those other things were established to preserve liberty. To ourselves and our posterity, right? That's the key, though, isn't it? Who are you living for? Because all those people in Washington, D.C. aren't living for our posterity. They're living for themselves. Well, you try to talk about denying the federal government power to your legislators, and they will tell you, well, if we deny the federal government power, then they will withhold money. It's necessary for us to have this money to run our schools. It's necessary to have this money to run our government. It's necessary to have this money to run our health care, our whatever, fill in the blank. William Pitt the Younger said, necessity is the plea for every infringement of human freedom. It's the argument of tyrants, and it is the creed of slaves. this election term, there's really only one vetting that you need to do to your state representatives, your county commissioners, your school board, your city councilman, and your sheriff. Just simply ask them, if the federal government asks you to do something that's against the Constitution, will you tell them no? Because if they do not, and I don't care what letter follows their name, R-D-I-L, I don't care. They must be fired. Ask them, just straight up, will you nullify unconstitutional federal law? That's a real good litmus. Watch their faces. And if they give you any one of those excuses, you say, thank you very much for answering my question. I will now no longer vote for you. Because you have just now declared yourself to be a tyrant. But now knowing that answer, if you do vote for them, you have just classified yourself under the creed of slaves. And you have no more excuses and no more right to complain. Somebody's going to say, but KrisAnne, what if both parties say the same thing? Then don't vote for either one. Write in a candidate.
What's the matter with none of the above?
Yeah, Nevada does that. Did you know Nevada has a provision on their ballot that says none of the above? Well, now we're going to talk about Article 5 very, very briefly. Sovereignty of the states is essential when understanding Article 5. You've heard it as a Convention of the States, whatever name it is, it falls under Article 5. Sovereignty is essential to the proper application of Article 5. If the states are not sovereign, they cannot amend the Constitution, right? Because they have no legal authority. Now, I can't go into, this is a very complex issue. As a matter of fact, I am developing a brand new seminar that covers all of this. How many of you have attended my 5-hour workshop? Okay. I am developing a new 5-hour workshop based on this course and based on my new book, Sovereign Duty. And so we would be able to address this in greater detail. But I want to teach you a couple things about Article 5 so you can make an absolute educated decision on whether you support this now or not. I have been accused of being an enemy to Article 5. Okay? I just want you to know that. I am not an enemy to Article 5. I am not opposed to Article 5. To oppose an Article 5 convention would deny a remedy that our framers put in our hands. It is in the Constitution. I have serious concerns about the application of Article 5, and I think you ought to as well. And so what I want to do is show you these concerns so we can make an educated decision. Somebody is going to tell you an Article 5 convention is a way that the states can circumvent Congress to amend the Constitution. That is an absolute and complete fallacy. And anybody who tells you that is operating outside the Constitution. Article 5 says, the Congress, on the application of the legislatures of 2/3 of the several states, shall call a convention. Congress must be involved because they have to call the convention. Not only that, that when the convention is convened and the amendments are proposed, it is up to Congress to choose the mode of ratification. So you cannot exclude Congress out of a process in which the framers have them written into the process. That would be outside the Constitution. Now, for me, these are the questions that must be answered in regard to Article 5 before we can ever get into something like this. Article 5 is like brain surgery on the Constitution. If your doctor came to you and said, we have found a brain tumor. Good news, it's operable. Just one operation, very simple, and we can get that done. Are you going to say, all right, doc, let's jump on the table and go for it now? Are you going to do that? Absolutely not. You're going to go get a second opinion. You're going to ask the doctor questions. What are the risks? What are the benefits? How do we avoid the risks? How do we improve our chances of success? These are the questions you're going to ask. These are the risk and benefit questions that we must ask before we jump into an Article 5. Who will be the delegates? This is the first and most important question that you must ask. And by the way, it's not my original concern or my original question. James Madison asked this question when they were debating over whether they should incorporate Article 5 into the Constitution or not. In Federalist 49, James Madison said, everybody here knows the only reason we were able to have a successful convention was because we had just come from a bloody revolution. And the horrors of what we saw kept us focused on liberty. We were able to set aside our personal greed, our political ambition, and all of our vain and our own arrogance. Because all we were focused on was liberty because of the revolution. He said, I fear in the future we will not have that same motivation. Which means the delegates will not have that motivation. He says, which means, I fear, we will end up asking the same people to fix the problem that created the problem. Who will be the delegates? 2 opportunities in an Article 5 convention. Your state legislators will choose the delegates. How's that going to work out for you, California? Are they going to choose constitutionally literate people to go? Of course not. At best, they'll choose based on party favor, right? And then it'll turn into nothing but a Democrat versus Republican dog and pony show. Second option, the people will choose delegates by popular election. How's that worked out for us? Again, it'll be a Democrat versus Republican thing. And then we'll be asking the Democrats and the Republicans to fix the problem in a convention that they created. How long will it take? I asked Michael Ferris this question. He said, well, KrisAnne, honestly thinking a minimum of 5 years. A minimum of 5 years before you see any product from an Article 5 convention. How many of you think we have 5 years to fix this problem? I'm going to tell you it'll be longer than 5 years because right now there are people with lawsuits that are already drawn up waiting for a convention to be called so they can file their lawsuits and drag this out as long as possible. Does Congress think how does Congress, oh, that's supposed to be how, not what. How does Congress think a convention will operate? You will be shocked to know how Congress thinks a convention will operate. Now, I can't tell you that. I have a whole chapter in my new book, Sovereign Duty, that will explain that to you. And I did a 5-part series on my radio show. 1 hour a day for 5 days. I went through a document published by the Congressional Research Service that compiled all the congressional hearings since the 50s on what Congress thinks an Article 5 is going to look like from their perspective. And I'm going to tell you what, they think they will run the entire show. Now, the Goldwater Institute contacted me while in the middle of my series and said, KrisAnne, we know this is a problem. We know all about the congressional research. We know all about Congress's desire and what they believe they're going to take control. So don't worry about it. Stop telling people about it. We have the solution. I said, I'm not supposed to educate our people on the truth about an Article 5 convention? No, we got the solution. We don't need to worry them about that. I said, no, I'm sorry. I'm going to keep teaching the truth. Thank you very much. You know what their solution is? We'll sue Congress to make them do what we want them to do. Must Congress call a convention? Well, Congress, according to their congressional hearings since the 50s, doesn't believe they have to even call a convention, even if the states produce enough petitions. Because in the my brain just cramped. Look it up in the book. It's either the 1920s or the 1950s. Congress was supposed to have a reapportionment of representatives, and the states demanded it, and they didn't do it. And nothing ever happened. And so what the Congress says, well, we established a precedent that when the state demands and the Constitution demands a reapportionment and we don't do it, there's no consequences. So the Constitution, we don't have to call a convention because we've already said we don't have to. A limited or unlimited convention. And how will that be controlled? Congress will tell you you can have a limited convention if you want, you just have to make us the controllers over it. Besides, a limited convention is a denial of state sovereignty. If you have a limited convention, meaning that the states who enter into that convention can only be debating on one subject, you have denied that state their sovereignty and their ability to represent the people. And they have to deny their people, deny their sovereignty, and submit to the authority of the convention, which will be run by Congress. And here's the big key. What is the president's role in a convention? Well, if you read Article 5, it isn't. He has no role whatsoever. However, since 1950, Congress has been debating that the president does have a role in a constitutional convention. And then what you're going to find is the states not just battling Congress for power in a convention, but also battling the president as well. So we have got to get these questions answered before we engage in brain surgery, because it's not just a light and transient thing. One final question I want to ask you. If we believe today the purpose of an Article 5 convention is to control an out-of-control government, how does a balanced budget amendment achieve that? Do you know there's a federal law that requires our Congress to have a balanced budget every year? So how would creating a balanced budget amendment stop Congress from engaging in unconstitutional power?
They wouldn't have the finances to do it.
No. We didn't take away their money. We just told them they had to balance the money we give them. They can still have it for the EPA and the Department of Education. We'll still fund them. They just have to balance the funding that they get.
Yeah, but they may not get that amount of money.
By who? By whom? Who's not going to give it to them?
Well, Congress is supposed to.
Congress is not supposed to be giving them the money for it at all. A balanced budget amendment just means we are going to give you money and you got to balance it. How hard is it to balance a budget when you have unlimited spending? Article 1, Section 7 of the Constitution gives the House of Representatives alone the power of the purse right now. Your conservative Republican majority, if they really didn't like what was going on in the White House, could defund it all by themselves right now. The Senate has no say. So you want to have a convention? Great. But you know what the amendment should be? Properly define the General Welfare Clause as James Madison has defined it. And then you will properly define the Tax and Spending Clause and the Necessary and Proper Clauses. And when you properly define those three things on a constitutional level, then you will have a surplus. Because at that moment, the EPA will be completely dissolved, the FDA will be completely dissolved, all of these hundreds of executive agencies that are unconstitutional will be completely dissolved. And you will not do that with a balanced budget amendment, but you will do that with the proper application of the General Welfare Clause. So, now I can't go over everything that we need to for the legislators because I have more time with them, but the Patriot Act and the national security letters should be null and void within your state. The FBI is an unconstitutional agency. There is no power in war, peace, negotiation, foreign commerce for the federal government to be policing law in our states. As a matter of fact, the FBI is unconstitutional because the majority of our federal laws are unconstitutional. Because they don't have the authority to write laws that are ruled in our states. The National Defense Authorization Act, which allows the indefinite detention of our citizens and transfers military power to the Department of Homeland Security. How many of you knew that it did that? The NDA transfers military power to the Department of Homeland Security, not through a declaration of war by Congress, but a declaration of hostility by the President. Isn't that great? The Food Safety Modernization Act. How many of you heard of that one? The Food Safety Modernization Act puts the FDA and the EPA and the Department of Homeland Security in charge of your backyard gardens, your roadside fruit stands, and your farmers' markets, if they deem it to be a matter of national security. The Transportation Research and Innovative Technology Act of 2012 has nothing to do with cars. Well, I guess some of it does. But this section here, Section 40304, allows the IRS to revoke your passport without any due process. They just simply have to assert that you are delinquent in your tax debt. The Federal Restricted Buildings and Grounds Improvement Act, H.R. 347, was passed also in 2012 by our conservative Republican House. And do you know what was supposed to be done? You know what that was supposed to prevent? It was supposed to prevent people from jumping the fence and getting into the White House. We had to have that, but you know what it really did? It made your First Amendment a federal offense if the government deems that you have interfered with the orderly conduct of government business. So if your congressman has a town hall meeting and you stand up and disagree with your congressman, he tells you to shut up and you say, "No, sir, I am just trying to voice my opinion. According to this act, you have now committed a federal offense punishable by 5 years in prison." Now, if you happen to live in a state where you can conceal and carry, or in Idaho where you can open carry, and you happen to be carrying a firearm at the time when you disagree with your congressman, you are now a mandatory minimum of 10 years in prison. You don't even have to use the firearm. You just have to be carrying it. And so we traded our liberty for something that didn't even work. World Heritage Council. How many of you heard of the World Heritage Sites? All of these dots, here's the United States, represent property and land that can be managed at the snap of a fingers by the United Nations because we've handed over the control of that property through treaties. Yeah, watch it. Go look it up. Go look up the World Heritage List. I see a couple places here in California that are now managed and maintained by the United Nations. The red ones are properties that the United Nations has deemed to be an emergency state and are already eligible to be managed by the United Nations. That red one right there is in Florida. That's the Everglades. We have sold our Everglades to the United Nations via treaty. And your states could nullify that. Samuel Adams said, "Let us remember that if we tamely suffer a lawless attack upon our liberty, we encourage it and involve others in our doom. It's a very serious consideration which should deeply impress our minds, that millions yet unborn may be the miserable sharers of our event." Liberty is not a gift that you purchase for yourself. Liberty is a gift you pay forward. And the liberty that we have squandered is the freedom and the liberty of our children. I just want to ask you, if the federal government is not defined by the Constitution, why do we have a Constitution? If the federal government is not limited in its power by the Constitution, then what is the limitation of the federal government's power? Its own will. Patrick Henry said, "It is natural to indulge in the illusions of hope. We are apt to shut our eyes against a painful truth and listen to the song of that siren till she transforms us into beasts. Is this the part of wise men? Are we disposed to be the number of those who, having eyes, see not, and having ears, hear not? For my part, whatever anguish of the spirit it may cost, I am willing to know the whole truth, to know the worst, and to provide for it. I've endeavored to teach you the truth today. What will you do with it? And the final question is, what kind of legacy do you want? We are very close we are just about to be the first generation to hand over less liberty than we have inherited on our own. We are already a generation of people who think that it's okay to have unlimited government regulation. From the cereal and the milk that we eat in the morning to the beds and the sheets that we sleep in at night, every aspect of our lives is now regulated by government, and the Supreme Court now says that even the government can regulate the air that we breathe. But we are doing something worse. We are now raising up a generation of people who will be comfortable with unlimited government surveillance. Emails, cell phones, cameras on every street corner. What do you want your legacy to be? Do you want us to be remembered as the generation that woke up and bought back our children's liberty? Or do you want to be the generation that said, no, I'd rather live in comfort, thank you very much? That sacrifice is just too great. Mercy Otis Warren, my favorite founding mother, said, we will stand against tyranny today, or our children will bow tomorrow. Winston Churchill said, if you will not stand for the right when you can easily win without bloodshed, if you will not fight for the right when the victory is sure and not too costly, you may have to fight with all the odds against you and only a precarious chance of survival. He said there may even be a worse case. You may have to fight when there is no hope, because it's better to perish than to live as a slave. You and I will not see that last consequence. But we will condemn on our children, our grandchildren, to buy back a gift that we were supposed to purchase for them. And they will not do it at the ballot box. They will do it with their blood. History proves that to be true. What do you want your legacy to be? I'm going to show you a little short video and then I'm done. Are you tired of people pointing fingers and laying blame? Isn't it time for some solutions? All right, let me show you the solutions.
It's become abundantly clear that the federal government is completely out of control. The executive branch transgressing every boundary established by the Constitution. Writing law, overturning law, setting aside law, and promising to do even more. Congress, with their political dog and pony shows they call congressional hearings, their refusal to use their constitutional power to limit this executive branch that's continually stealing their legislative power. Through their inaction, they have made themselves irrelevant and impotent and have contributed to the destruction of our Constitution and the republic that we know and love. And the third branch of government offers us no greater hope. After all, this is the Supreme Court that ruled that health care is a power rightly wielded by our federal government, and that the EPA has the right to create law through regulation, never once addressing the fact that the EPA does not constitutionally exist. No, the federal government is not our hope. The federal government is not going to provide the solutions to our problems. The genius of our framers is that they gave us a constitutional republic, not a kingdom. They gave us options. Do you want to defend liberty? Do you want to defend this republic? Do you want to defend the Constitution? My book, Sovereign Duty, will give you that plan. Let's get educated. Let's defend liberty. It's our sovereign duty.